Hello everyone, this is Kartik from the Indian Lawyer and Allied Services, and welcome to another episode of TIL Legal Tips. In today's digital age, our lives are increasingly intertwined with technology. From social media to online shopping, our personal data is constantly being generated, collected, and shared. But with this convenience comes a pressing concern. How do we ensure the safety and privacy of our personal data? In this video, we'll explore the key components of the Digital Personal Data Protection Act, its significance in today's digital landscape, and how it impacts us. Joining today with us is Mrs. Sushila Varma, Chief Consultant at the Indian Lawyer and Allied Services. Thank you for joining with us, ma'am.
Thank you, Kartik, for having chosen this topic. I must say that data protection law is an extremely important topic in today's day and age. The reason is simple. All of us, at some point of time or the other, have been bombarded with invasion of our privacy by way of SMS, emails, WhatsApp messages, and phone calls in which we are sold something or the other. All these marketing gimmicks that are followed by companies through their telemarketers has to stop, and the Data Protection Act is one such act which will put an end to this meaningless marketing which has disturbed all of us.
So the first question for you today is, what is Data Protection Act and when did it come into force?
Now, answering your query on what is the Digital Personal Data Protection Act 2023, let me answer it simply. It's the first law in India that protects the privacy rights of its individuals. This act is the outcome of a nine-bench Supreme Court judgment, which is K.S. Puttaswamy versus Union of India, where the Aadhaar card issue was discussed. In this particular matter, the courts held that every citizen had a fundamental right of privacy, and because there was no law in 2017, this particular judgment was the forerunner of the Digital Personal Data Protection Act 2023. It is yet to be enforced as the rules have not yet been passed, but finally we have a law that will protect our privacy and our rights to decide who we want to speak to or who we do not want to speak to.
Very well. Now coming to the next question. What are the primary objectives of the Act and who does it apply to?
Now, let me give you some information as to what the Digital Personal Data Protection Act 2023 deals with. The acronym for this act is DPDP Act, and it deals with personal data privacy. That is, whatever data we are sharing with third parties cannot be treated in a manner that will help marketers to access our information and use it or rather misuse it to their advantage. The Digital Protection Act provides a mechanism by which all data collected online or offline by physical means is stored and protected in the interest of the citizens of India. The DPDP Act aims to protect individuals' personal data from unauthorized access and ensures a transparency in the data processing practices that are followed in India. Most importantly, it establishes a mechanism for accountability and redressal in case there is a data breach.
Okay, so the next question to you is, what is a data principle and what are its rights and duties?
Now, let us talk about some important aspects of the Data Protection Act. The first is data principle. Who is the data principle? A data principle is anybody who shares their personal data either to the government or to a private organization. So, when we say data principle, you are a data principle, I am a data principle. Now, let us come to what are the rights of a data principle. A data principle has the right to seek that his or her information be kept safely, that in case there is any correction required, the correction should be done, the data principal also has the right to nominate another person to exercise his or her rights in case of death or incapacity. And most importantly, the data principal can seek redressal from the grievance redressal mechanism if his or her data has been breached. But that is not to say that the data principal does not have any duties. Yes, as a data principal, we have certain duties. The first duty is that we should not furnish false and particulars and information or impersonate any other person. Secondly, we should not register any false or frivolous complaint. And in the event that we violate these duties, there is an offence punishable by a fine which is rupees 10,000.
Very well. Now, coming to the next question. Who is a data fiduciary and what are its obligations?
Now, another term that needs to be explained is data fiduciary. Now, who is a data fiduciary? It is any entity, institute, or person that collects, processes, or controls the personal data of individuals. The data fiduciary has a responsibility of handling all such data very carefully and in a manner that personal data is not leaked out. Now, let us dwell on what are the duties of a data fiduciary. I would say the first is to make a reasonable effort to ensure the accuracy and completeness of the data he or she is collecting. Secondly, to ensure that there is a system of security and safeguards to prevent data breach. Thirdly, the data fiduciary has to inform the Data Protection Board in case there is a breach of the security of the data he or she has collected. And finally, the data fiduciary has to erase all data once it has been utilized in order to ensure that there is privacy for the data principal.
Okay. So the next question to you is, who is a data processor?
Another definition that needs to be explained is that who is a data processor? Now, a data processor refers to any entity who processes the personal data or uses the personal data which has been collected by the data fiduciary.
So my next question to you is, who is a consent manager?
Now, coming to the next important definition, that is, who is a consent manager? A consent manager is a tool or platform used by an organization to manage and document the consent obtained from all individuals for the processing of their personal data. As per the function, one can see that this is an extremely important aspect of the DPDP Act, and it plays a very crucial role in the protection of the data that has been collected.
Very well. Now, can you tell me what is a data protection board and what role does it play in this act?
Another important aspect of this act is the Data Protection Board. This is an adjudicating body which has been set up by the Government of India, and it looks into the disputes between those people whose personal data has been given to a platform and which in turn has breached its duties and obligations under the DPDP Act. The central government has imposed certain obligations or certain duties on the Data Protection Board, and these are monitoring compliances and imposing penalties, directing data fiduciaries to take necessary measures in the event of a data breach, and hearing the grievances of all affected people and passing orders accordingly.
Okay, so my next question to you is, what constitutes a personal data under this act and what is the personal data breach?
Now, coming to probably the most important aspect of the DPDP Act, that is, what is personal data breach? In order to understand this, let us understand what is personal data. Personal data refers to any information relating to an identified or identifiable natural person, such as the name, the address, the contact details, the biometric data, the medical records, or any other online identifiers. Now, any authorized processing of such personal data, whether it's deliberate or accidental, or has been acquired or shared without permission, or has been destroyed or lost which in any manner compromises the confidentiality of the concerned person will be deemed to be a personal data breach and is an offence punishable under the DPDP Act.
So, coming to the last question of the day. Now, there are cross-border transactions happening every day between the citizens of India and the foreign companies. For example, the foreign companies, while hiring people from India, usually ask for personal data of the candidate who is from India. Now, how has the Act defined the cross-border transactions, and is it permitted to share your personal data to a foreign entity?
Now, answering Kartik's last question as to how the DPDP Act promotes cross border data transfers. Now, this Act has provisions for exchange of cross border data, that is, transfer of data from India to third countries. However, the Act mandates that such data which is transferred from India to overseas must be adequately protected and must be safeguarded, and all the rules and regulations that will be formulated under this Act have to be followed by the book. There is another rider to this entire provision, and that is if a foreign company has engaged people in India and has access to their data, that data can be transferred only if the company that is operating in India is not blacklisted or is not in trouble with the government. In the event that such a foreign company has been blacklisted by a notification of the government, then such transfer of information will be wholly illegal and severe action will be taken against such companies. Viewers, please note that this is an effort from the Indian Law and Allied Services to give you a broad-based idea on what the data protection laws in India mean. It is certainly a burning topic and we all need to be educated on what our rights are. But please note that till the rules are out and notified, the law is not really strictly in force. So you still have to be careful when you are giving your data to third parties or processing your data through some third parties. A small request, if you have found this video useful, please like, share and subscribe to encourage us to help you understand different aspects of the law. Thank you and Namaste.